Today's question comes from Unity, Wisconsin, and it says the following. My dad passed away. He deeded the house to me. It is already deeded in my name. Do I have to give my sibling anything? The last will and testament says it is to be split equal, but is already deeded in my name. So this is a very good question because we see two issues here. One, a transfer during life, which was when the father deeded the home to the son, and two, the last will and testament, which only takes effect upon the father's death. So if your father validly transferred it to you during his life as a gift, then that asset was removed from his probate estate, because the will covers everything else. Everything without a title or with a title that's otherwise not disposed of. So if he transferred the house to you, let's say as a joint tenant, then with rights of survivorship, then you take all of it upon death. However, you need to check how the title was transferred. If it was solely out of his name into your name, then you own it. If it was just partial interest, then you have that partial interest, and the will would dictate what happens to the other part. But for my other listeners watching, be careful that what you do during life lines up with what you want to happen at death. Because if this father really intended that the children split the house, then he shouldn't have transferred it during his lifetime solely to one child. But to you, the questioner, you may own 100% of the house. Now, the will would dictate what happens to everything else, such as any other real estate he owned, bank accounts that weren't titled to pass non-probate, or anything like that, vehicles, etc. So again, it sounds like from the facts you said here that if it was deeded solely into your name, then you would be the owner of the house, and the will would just dictate any other assets that had not been transferred or disposed of by a transfer on death or beneficiary designation at death. So good question, and thank you for asking.